Mr. Spence, just before we get to the question that I asked you before lunch, perhaps we can deal with the document you mentioned earlier. I'll hand you a copy of a document. Is this the document you were referring to, Mr. Spinks, when you said there was a 1998 document that you were able to find?
That's correct.
And on the third page, in the second paragraph, number 2, in other words, beneath the heading before forming a judicial committee, is that the paragraph you had in mind?
That's correct.
So it asks the question, when is it not advisable for the witness to confront the accused alone? What should the elders do? And then the answer is given when he is a party to the wrongdoing, is a victim, or is extremely timid. Children who are victims of molestation should not be required to confront the accused. In some cases, 2 elders or an elder and the witness can confront the accused. And this document you found in the circumstances you explained earlier, is that right?
Correct.
I tender the document, John.
What is the document? What is the document? What do I call it?
Your Honour, I'll ask the witness. How should we properly title this document, Mr. Spence?
We know it as an S337 form, which is the 6-monthly outline that the circuit overseer, the travelling overseer, meets with all the elders in his circuit to discuss. So it's the circuit overseer's outline for the elders meeting, S337.
We'll make the document 2920. What's the paragraph that you just took us to?
On the third page, the second paragraph, number 2, in other words, beneath the heading before forming a judicial committee, 4 minutes, and then there's this paragraph number 2.
Well, I'm not sure I've got the right document. Yeah. Where? Oh, I see. The second 2. Yes, I see.
Yes, Your Honour.
Very well. Yeah. Yeah.
And are we to understand, Mr. Spinks, that this applied in the 6-month period, September 1998 through to February 1999?
The circuit overseer would have met with each body of elders successively through that 6-month period.
And that paragraph doesn't appear, I take it, in subsequent S337 forms?
No, each one is completely different.
Yes, thank you.
So I understand the paragraph. The question is, and this contemplates one of your members asking a question, when is it not advisable, is that right, for a witness to confront the accused alone? Now, what should the elders do when he is a party to the wrongdoing? When he is a party, is a victim, or is extremely timid? I'm not sure I'm understanding. Children who are victims should not be required to confront the accused. Can you help me to understand the English of this?
Certainly. So just the format, if I could briefly, is a question and answer discussion. So the circuit overseer would present the question, open it up for responses is the usual format for these meetings. And then the bracketed section is for him to either redirect or help the elders to see that this is the correct response. So in that it says, so we're now talking about the witness, victim, whichever. It says when that person is a party to the wrongdoing in one instance, so perhaps a shared sin, if that were the case. That wouldn't be appropriate. Secondly,
sorry.
Yep.
What wouldn't be appropriate?
Well, for example, we wouldn't be suggesting that the party to adultery, for example, would be required to confront the accused in that setting. So that's one scenario that where the witness is actually a party to the wrongdoing, involved in the wrongdoing, that wouldn't be an expectation. And then, or is a victim, so, or is extremely timid. So there's just some examples of settings where it wouldn't be appropriate.
Children, what about women who were abused as children? In other words, adults who come forward with an allegation that they were abused when they were a child.
Well, then they'd be a victim in that first sentence.
Right. Now, in some cases it said two elders or an elder and the witness can confront the accused.
Mm-hmm.
So does that mean if an elder does it, they would do it with the witness? Is that the way that works?
Difficult for me to go back and interpret it fully, but how I would read that and read it at the time, that either two elders could confront the accused, or one elder and someone who's a witness to a particular type of wrongdoing.
And the elders again would be men?
The elders are men.
So in the scenario we contemplate, the child or adult abused as a child has to put their story in the hands of two men. Is that right?
I think we've given examples through all the recent case studies that that's not an expectation that we have. Each of the cases that I reviewed back from recent times back show either the parents, a caring guardian, a friend, whoever it is, can work with the victim to have that put in writing. We don't see that there's a situation where the victim, unless they choose to do so, perhaps in the case of a mature minor or a survivor, might choose to do that, be happy to do it, but otherwise a statement, a written statement, either provided by the victim or a survivor, or recorded by a witness and an elder or two witnesses would be sufficient.
Yes.
Well, Mr. Spinks, that is under the heading before forming a judicial committee, so that applies during that stage. Is that right, the investigative stage?
That's what that's referring to there, yeah.
And then the next heading is judicial committee hearing procedure, and you'll see in paragraph 2 the instruction is to explain what is to be done if the accused person does not admit guilt. And then in parenthesis it says the alleged wrongdoer has right to face his accusers. Are we to understand that in the judicial committee process, if the accused does not admit guilt, then the victim must make the allegation to the accuser?
No, that's not correct. And that's covered in questions that you've raised previously in the process of the judicial committee, where it says if for some other reason the letter presented to the accused is sufficient to face the accuser. So we wouldn't expect that a victim or a survivor would have to face the accuser, except in some instances where they wish to do that, and I am aware where that's happened on occasion, or that would be exceptional.
Well, would it be the case that one would expect circuit overseers who were presenting this discussion with elders in a particular 6-month period to have conveyed to the elders that the alleged wrongdoer has a right to face his accusers in the judicial committee procedure?
I think I understand. Could you just repeat that for me again, please?
The people to whom this was presented, I understand this is an outline for it, a discussion, a led discussion by circuit overseers. The persons to whom this was presented, the elders at that time, would from this, I take it, have understood that the alleged wrongdoer has a right to face his accusers in the Judicial Committee hearing procedure.
I think by default, this was in 1998, so the previous Elders Handbook, the KS 91, would have spelled out that procedure, and that may have already been mentioned through the course of the Commission. This statement here, and the comment I referred to from the 95 Watchtower, is clearly our realisation, or the beginning of our realisation, that there are situations that are exceptional and no more exceptional than a child abuse situation or a survivor or victim. So this is actually stating that there need to be exceptions to that usual judicial process.
Well, it's only stating it in respect of the pre-judicial hearing component. I mean, you agreed with that earlier.
That's
yes.
That's the subheading there, yeah.
Now, Mr. Spinks, getting back to the question I asked you just before the adjournment, have you been able to identify those components to the procedure that are scripture-based in such a way that it would not be open to you to divert from them?
I took the question away with me. I'm happy to comment on it. It's a reasonably wide question. I think you used specifically what you called the two witness.
I used that as what occurred to me to be an example of such a scriptural principle that can't be departed from.
That's correct. So if the question is, are Jehovah's Witnesses likely or open to changing the what we would see as a scriptural requirement repeated by Christ Jesus himself, that before you could take judicial action in the absence of other evidence or confession, that aspect of the process would need to be held in abeyance? Do I think that there's flexibility to change that? I don't see how, because it's a clear scriptural injunction. Is it right to say that because of that one witness rule, nothing can be done and nothing is done? That's certainly not the case, and the 2012 letter spells that out as well.
Well, perhaps we can come to those aspects in a minute. I'm just asking you to identify those aspects of the process which are scripturally based, such that you're not in a position to change them even if you wanted to. So you've identified the two witness rule as one component. Are there others?
I'm probably struggling. If you have a suggestion, I'm happy to listen to which component, but it seems to me that scripturally the two things that have been by His Honour and yourself raised are the process of having women involved in the judicial process as elders, as it were, or the requirement for, within our rules of evidence in handling a matter, in the absence of a confession or circumstantial evidence or other indicators, would we act judicially on one witness, as the courts may do? The answer would be no, and I don't see that changing in harmony with the scriptures.
Well, Mr. Spinks, we've already identified that. I'm now trying to see whether there's anything in addition to that. So, for example, I take it that it's a requirement of the scriptures that it is the elders who act judicially and not anyone else.
That's correct.
And I take it that it's a requirement of the scriptures that elders must be men and can't be women.
That's correct.
Are there other components of the process that the scriptures require? for example, that the accused has a right to face his or her accuser?
I think we've discussed that. We have no expectation of a victim or a survivor having to face and there's nothing unscriptural about that.
So
they could do that in the form of a letter, as we've explained, or a statement, or other witnesses, and the investigation, the judicial process would gladly accept that.
So your understanding of the scriptures is that that's not a requirement of the scriptures, that the accused makes the accusation to the accuser?
Well, I think clearly, as with any rules of evidence, the accuser has that opportunity, whether that's via a letter, statement being presented with the facts, that conforms perfectly with the scriptural requirement.
What about in respect of outcomes? Is there a scriptural requirement with regard to what are the possible outcomes from a judicial process?
I think the scriptures are clear that they're 1 Timothy 5, 1 Corinthians chapter 5, where it talks about removing the wicked person, a practicer of wicked. So will Jehovah's Witnesses continue with the practice of excommunication, despite the fact that it's a rare arrangement in 21st century Australia? Yes, we will, because it's scriptural. Will we continue with the scriptural practice of reproving individuals who have shown themselves sufficiently repenting, or reinstating into the congregation individuals who are sufficiently repentant? That's all clearly set out in the scriptures.
And any other aspects of the judicial process you'd like to identify as being based on the scriptures such that you could not depart from it?
I can't think of a specific thing, but I'm happy to comment if there was something specific that you had in mind.
Well, perhaps something will arise. Okay. I'll ask you to take a look at tab 126. It should come on the screen before you. Now, this is a letter from the World Headquarters to all branch committees, and one would anticipate it to have gone to all branch committees throughout the world. Is that right?
That's correct.
And it attaches, if you can look at the next page, guidelines for branch office service desks. And this deals with, amongst other things, dealing with allegations of child sexual abuse. Is that right?
Yeah, that's correct.
So in your branch office service desk, giving guidance to elders and congregations when they call, you in turn will be guided by these guidelines. Is that right?
That's correct. Most of it, yeah, that's correct.
And if you take a look at page 9, which is the second last one for ringtail purposes. I think it's 84. There you go. And in particular, question 14, if you can scroll down. So this, as I understand it, sets out revised guidelines on interviewing a young child who's a victim of child abuse. Is that right?
That's correct.
And 46, 846, it says, when the elders call the branch office regarding a child abuse matter, they may ask about the need to interview the victim. Such cases help the elders to balance the need to investigate with the dangers of inadvertently further traumatizing a young child abuse victim. For example, has the accused already confessed to the wrongdoing? Is there more than one accuser and thereby already sufficient evidence to handle the matter judicially? In such cases, there's likely to be no need to interview the young child. So if there isn't the further evidence referred to, then if the investigation is to proceed to the next stage, then there would have to be an interview with the child. Is that right?
If that's what the parents, if that was the wish of the parents, that's what these guidelines are for. If the parents still wanted to pursue that matter, that's some suggestions there, that's correct.
Well, equally, if the elders wanted to pursue it.
Well, the elders aren't authorised. I think that's made clear. The elders are never authorised to act with regard to a child without the consent or request of the parents.
But isn't the result that in circumstances where the allegation is made, and maybe very credibly, if there isn't other evidence and to interview the child would be too traumatic for the child, so the elders are reluctant to do that, they would then be left not being able to act judicially. Is that right?
That's correct.
And that's not a good place to end up, is it?
Absolutely. Yeah.
So what can or should be done about that?
I think we come back to the same question of, at that point, the parents would be made well aware that the elders are limited with regard to judicial action in some circumstances, and they would be transparent with the parents with that. The parents would be reminded that it's their absolute right to take this to the authorities, and the elders will support them in it. That is repeatedly the advice given, and if I can add that, in each of the calls that we've taken at the branch office in the time that I've been there and prior, we also have the elders, if the offender is known in the congregation, the elders also inform the offender that the parents have been told they will have the full support of the elders in taking the matter to the police.
Well, that suggests in some sense it's better if the child can't be interviewed or shouldn't be interviewed, because then the matter is more likely to go to the authorities than otherwise.
We're always happy if the matter goes to the authorities. I think we never suggest that the spiritual handling of the matter within the congregation in harmony with Bible principles is ever a substitute for the matter being reported to the authorities. We never suggest that.
If you look in paragraph 49, the first dot point, so this is dealing with conducting it says conduct the interview in a loving manner, and there's a scriptural reference that says, although it is preferred to have only one elder conduct the interview, another elder should be present as an observer. So, as I understand it, it is the requirement that two elders are nevertheless present.
That's the case. If the parents are happy with that arrangement, it would be. The reason I'm probably just struggling a bit to do it because we've never done it, Mr. Stewart. I appreciate that that's here and it's an option. It's a worldwide document. We've never done this in Australia, but I still think they're reasonable suggestions should that option be taken. So I'm not stepping away from what's there. It does say another elder as an observer. We've not pursued matters that way, but that's the suggestion that's being made there, certainly.
Now, you would accept that, for the most part, neither elder would have had any specialised training in interviewing children who have suffered trauma.
That's quite probable.
And you would accept that such a specialist from the authorities would know how to avoid the contamination of evidence, avoid being suggestive or closing down evidence.
Yes.
In the case of a child, then, shouldn't there automatically be a report to the child protection authorities at a minimum?
Well, that comes back to the same question which we've answered. I'm certainly happy with that arrangement. I have my own personal views and conscience on it. Have we as an organisation directed elders to do it, or have we done that? I think the answer's been clearly no, despite the fact there's been many instances of police involvement. We've not claimed to have done that as an organisation.
Because if that was the first step, then there would be no need for the elders to be interviewing the child, would there?
I think that's fair to say, correct, yeah.
Now, just on the question of sufficiency of evidence in order to act judicially, I understand that what's required is a clear and unambiguous confession, or 2 or 3 witnesses to the same event, or to separate incidents of the same kind of wrongdoing. That's the position, isn't it?
That's correct.
And that remains the position today, as I understand you said.
That's the broad principles, yeah.
Yes. And of course you accept that in the case of sexual abuse, more often than not, there will be no second witness.
To the assault, correct.
Yes. And do you accept it's also the case that sex abuse allegations by children are almost always justified?
I've certainly read that to be the case. I have no reason to question that in most cases, yeah.
Well, it is in the Watchtower's own publications. Is that where you're referring to?
It probably is, but I've certainly read it externally as well. I have no question over that. I agree with what you're saying there.
Well, I'll just refer you to it quickly at tab 8T, page. I've got the wrong reference, sorry. Indeed, I have got the wrong reference, but it's a Watchtower publication I can come back to. And as I understand you, you identified this sufficiency of evidence as being scripturally based, and you can't depart from it. Is that right?
For taking a specific action, judicial action,
Yes.
that requires, by our rules of evidence, those things that you refer to. Yeah?
Insofar as a second witness is concerned, is that requirement covered by, for example, scientific evidence?
Certainly.
So if there was some external forensic, scientific or direct evidence which is not of an observer to the incident, but someone who observes some corroborative aspect to the incident, that would be sufficient, would it?
We go much further than that, Mr. Sheridan. The answer is yes. We've disfellowshipped people for being in an inappropriate setting with a child where there's an allegation or they've been warned. So I think that if I can clarify that, while we've acknowledged the concern over the fact that 2 witnesses are required to say that a specific act took place with regard to sexual assault, and we completely understand the limitations there, but a witness to say that an individual came out of the child's room where they weren't entitled to be. I recall one incident where an individual was kneeled down with a child in the toy section of a department store, and it was dealt with because there was an allegation and he had been warned. So I think the thing to have real clarity on is that we are not talking, we're not so naive as to think that there's going to be a second witness to a specific act of sexual assault, but we, as the case files will show, have disfellowshipped people for being in an inappropriate setting where there's some allegation. 2 witnesses are not required to that specific act, but is there a limitation at times for proceeding further judicially in some regards? We acknowledge that.
If I can take you to the Shepherd Handbook at page 72. So that's tab 120. See at the foot of the page, paragraph 39, dealing with if the accused denies the accusation. So this is in the section dealing with the investigation. So prior to judicial committee being formed, you'll see about 5 lines from the end, it said if the accuser or the accused is unwilling to meet with the elders, or if the accused continues to deny the accusation of a single witness and the wrongdoing is not established, the elders will leave matters in Jehovah's hands. So we to understand that if there isn't a second witness or other evidence sufficient to satisfy that requirement, as you've explained, and there isn't a confession, and the accused refuses to meet with the elders, then the matter's left.
That's not correct. That, I think, as you're aware, that section is specifically dealing with judicial action, where scripturally, and I feel obliged if I can, just one verse, just to show why I say that. If I can just flick it over, I think it's in. If I can, 1 Timothy chapter 5. Should I continue?
Yes, go ahead.
After verse 19, talking about 2 or 3 witnesses, verse 24 says, the sins of some men are publicly known, leading directly to judgment, but those of other men become evident later. Verse 25 says those that are otherwise cannot be kept hidden. So the matter is not concluded,
Sorry to interrupt you, Mr. Spinks. I should have clarified my question or put it clearer. What I meant is, insofar as judicial action is concerned, the matter is concluded. Is that right?
if there's no second witness or evidence to a disfellowshipping offence, not necessarily the specific sexual assault or act, but corroborating evidence, as I've mentioned, such as inappropriate contact with a child where an allegation exists, that would be considered as evidence. The individual may not be disfellowshipped for the specific sexual act that's been alleged, but as has previously been described, they would be or could be disfellowshipped for brazen conduct, which, as described in the Elders' Handbook here, is conduct that is shocking to us in general, the community, and in violation of Bible principles. So even things like sexting, child pornography, an inappropriate setting. So to your specific question about two witnesses to a specific sexual assault, we know that that would be an exception, but there are often circumstances surrounding that, in fact perhaps more often than not, that substantiate the claim of the victim.
I just want to deal with outcomes in relation to the judicial process. As I understand it, once a judicial committee is formed and deals with an allegation, the first outcome is guilt or innocence. In other words, is it established or isn't it? Is that right?
Correct.
And then the second outcome is, if guilt, then there's an inquiry as to repentance.
Correct.
And if there's repentance, then there's reproval and not disfellowshipping. Is that right?
That's correct.
And if there isn't repentance found to exist or sufficiently, then there's disfellowshipping.
Correct.
And insofar as repentance is concerned, those requirements are set out, are they, in the Shepherd Handbook, so that's tab 120, page 91. And onwards through to page 94, is that right?
That's correct.
And as I understand it, it's not part of that assessment of repentance, any risk or assessment of risk of reoffending. Perhaps I can qualify that. other than a belief in what the offender says in that regard?
Well, I think that would be the case in any judiciary, that without having a crystal ball or being able to look back, any claims of regret, repentance would have to be determined at the time. But what you say is correct.
Well, the difference in a civil court setting, for example, is that there are likely to be expert reports from psychologists and others as to risk of reoffending. That wouldn't be part of your judicial process.
That's true.
And you would have heard Dr. Applewhite give evidence that once somebody abuses, once their internal mechanisms of control have allowed them to cross that line once, she said, I don't have confidence in those internal mechanisms of control for the future. Is that view, which is supported by some of the writing, is that something which has been taken on board by the service desk?
I think even what's written, whether we understand that as well as the expert witness, I think is a valid point. But do we understand that somebody who has abused a child can offend again? Yes, very clearly. Does that move us to say that we will never allow a child abuser to return to the congregation, that we do not believe, despite our Christian faith in the power of God's word and people's capacity to change, that someone could never be rehabilitated? I think if that was the case, no one would be released from prison. There'd be no programs in place. So we're not naive as to the fact that a child abuser can reoffend, and that's written in our own publications. Are we going to stop rehabilitation when an individual, including BCH, if that's what it was, when he was disfellowshipped from the congregation for a comparable period to which he was in prison? He still remains disfellowshipped because he's never apologised to his daughters. He's not made restitution. He hasn't admitted it. But he was released from prison and into the community, rehabilitated. His neighbours don't know who he is. So my point is, I understand the challenges of what you're saying, but unless we're going to say child abusers are never to be released into the community, never released from prison, then we, Jehovah's Witnesses, will keep doing our best, take on board what we've learnt through this process and beyond, and adjust our procedures. But it would be unchristian of me to say that even though nobody else that I'm aware of does it, we'll stop allowing a child abuser to return as a restricted attender at the meetings.
Mr. Spinks, I think you missed Mr. Stewart's point.
I apologise.
What he's pointing out to you is that the civil authorities have available to them a number of mechanisms from the learning of science in relation to the evaluation of the risk, and also, as you probably know, there are processes of treatment.
Yes.
Which may be controversial, but nevertheless they're used. What he was pointing out to you was that none of those mechanisms are available to the church, correct?
That's correct.
So the decisions you're making are being made without the benefit of the learning that's accumulated now over a number of decades.
Yeah, I take that point, thank you.
Well, it's a good point, isn't it?
Your Honour, I take it, and again, I don't want to be disrespectful from a personal point of view. I don't think our system has the authority, or as you say, rightly, the expertise of the... But for my personal dilemma, again, as a father and grandfather, I'm struggling. I'm happy to see the deficiencies in our system and 100% motivated to be a part of the solution, absolutely. Where I'm struggling is the fact that the individual was released back into the community without any constraints. The end result is the only people that are refusing to let him be rehabilitated in our community are Jehovah's Witnesses. He's out there in the wider community, but I see the limitations of what we have.
Mr. Stewart's not pointing out the particular. He's asking you to consider the matter in general. Do you understand?
I do. And I agree.
And to say it again, what he's saying to you is that the processes that society have aren't used by the Jehovah's Witnesses to evaluate the risk that's involved.
And I agree. I accept that, Your Honour.
And do the Jehovah's Witnesses engage at all in treatment for offenders? In other words, where someone is found to have offended and perhaps faced up to it, confessed to having offended, do the Jehovah's Witnesses engage at all in assisting that person in getting treatment?
So professional treatment, medical, psychiatric, I think we've answered that no. The role of elders in the congregation is a spiritual one, and we don't claim to have that expertise.
Well, I think in some other churches, for example, they would say the same of their priests, but they have nevertheless set up programs for offenders and supported offenders through those programs. And I'm just wondering whether the Jehovah's Witnesses have done anything like that.
No.
I take it not.
No.
Yes. Just the reference I missed earlier was actually tab 82, page 6. It's ringtail 241, I think. You'll see when it comes up, it's the Awake publication, October 8, 1993. If we can scroll down a bit. Under common misconceptions on the left-hand side, the second one, misconception, children fantasize or lie about sexual abuse. We could scroll down a bit further. And you'll see it says that even the most skeptical of researchers agree that most claims of abuse are valid. And then various references are then put there.
Yes.
Yes. Now, Mr. Spinks, I'd like to deal with just some of the figures that you raised earlier. And in that regard, I have some documents to show you.
Thank you.
So just to explain what this bundle of documents is, and I'll tender it in due course, is the first document is a summary of Watchtower Australia case file analysis. So in other words, this is the staff of the Royal Commission assisting me. It's their final version of the summary after the correspondence which then follows that had passed between the Royal Commission and the lawyers representing Watchtower Australia. And so this is the position we've landed up with on the figures. And to deal with a couple of the figures that you raised. So you said, as I understood it, that, well, I'm reading from the transcript for those who have it, it's page 15663. You said earlier that almost 400 of the 1,000 cases over 65 years have had the intervention of the authorities. Now, that, as I understand it, will be a reference when, if you have a look, the first letter behind the summary is 16 July 2015. Do you see that? Then the
Yes.
second letter is 20 July 2015. Do you see that?
Yes.
And if you go to page 9 of that letter, so it's a letter from Milton Bray and Associates representing Jehovah's Witnesses in Australia to the Royal Commission. And in particular, paragraph 10, you'll see that it said there, my client is unable to provide any assurances as to the accuracy or completeness of the number 161 that you indicate have been convicted of a child sexual abuse. Nevertheless, by searching key words, i.e. police, child services, authorities, charge, court, welfare, etc. in the case files, and upon careful review of the information contained in there, my client was able to establish that 383 alleged perpetrators have been dealt with by either the police or secular authorities in the respective states or territories in which they reside. So, not that I'm quibbling about the difference of 17, but just so that I understand, is this the figure you're really referring to, the 383?
Yes, I don't know that I actually knew the exact figure. I think, as you're aware, I came from hospital to be at the process. I haven't been involved in any of this correspondence, but the figure that was given to me was somewhat under 400, so I'm certain that would be the case.
All right. So I didn't know that you had not been involved in this correspondence or in looking at these figures. So it is perhaps the case I should ask someone else about them. Would that be right?
I want to be helpful. I unfortunately wasn't available. I understood. I was informed that these figures were presented a week or so before the commencement of the Royal Commission. I think, as you're aware, I was in hospital for the week, so I got a few informal figures that I can't verify. I don't know what they're based on, and so can't really comment on that yet.
Well, just in relation to the other figures you gave, though, you said that only 2 elders and 4 ministerial servants have committed child sexual abuse in the last 10 years. Is that right?
That's what I was informed.
Yeah. And so that's to say that there are reports of incidents in that period of 10 years amounting to 2 elders and 4 ministerial servants having committed child sexual abuse. Is that right?
Again, what I'm reading, if you're pointing to Table 3 on page 5, what I'm reading is a heading that says number of alleged incidents over the past 10 years. So beyond that, I'm not certain. That would seem to me to make reference to incidents of the past 10 years. Beyond that, I'm not certain.
All right, that's fine. I just wanted to clarify that. So that's not the number of reports. There have been 289 reports in the last 10 years. Of those, most of them relate to to incidents that occurred in an earlier period. You accept that?
Well, we're not comparing the 2 elders with the 280, whatever it was. That's total reports. I'm sure that's right. I'm not certain.
No, I'm just clarifying what it is that you were saying. And your evidence was that 199 of the 1,006 cases relate to individuals who are not Jehovah's Witnesses at the time. In fact, the position is that they were not Jehovah's Witnesses at the time of the first report, but they were subsequently, and there may, in many of those cases, have been subsequent reports of subsequent allegations.
I'm certain that a good percentage of those, if those are people, and again, I'm only being cooperative and helpful in saying this, I'm certain that a good percentage of those would have went on to be Jehovah's Witnesses. I think the issue was that there were people at the time that weren't Jehovah's Witnesses. What you say is probably true.
At the time of the first report in relation to them?
I don't know the figures on that, but I've no reason to question what you're saying.
Yes. And now, Mr. Spinks, you also furnished a second statement dated 24 July 2015. Do you have that statement?
Well, I think we should mark these documents, shouldn't we?
Oh, I beg your pardon. I wish to tender that as a...
We'll make the documents together. The summary of case file analysis, those documents together are Exhibit 2921.
I'm advised that redacted copies will be distributed and published. So the copy that's been given to Your Honour and Millen and Friends for now is as yet unredacted.
Very well.
Mr. Spinks, do you have a second statement, 24 July 2015?
Yeah, I do.
Do you confirm that that's true and correct?
I do. I wonder if I could ask, with respect, if we could just have a brief convenience break. Would that be possible?
I'm about to end it, and unless you need it immediately.
No, thank you.
So you confirm this is true and correct?
Yes.
I tender the statement, Your Honour.
It'll be Exhibit 2922.
On the Honour, at the witness's request, might we have a short adjournment?
Yes. Let me know when we're ready.
Silence, all stand.
Come back to one last aspect about reporting before I finish, and it's this. As I understand it, within your faith and you indeed as a person, if you saw someone breaking into your neighbour's house and your neighbour was away, you would, first thing you would do is report it to the police, wouldn't you?
Yeah, that's true.
And if you received reliable information, and I understand this is hypothetical, you've never been in this position, but if you received reliable information that a murder was planned, the first thing you would do is report it to the police.
That's true.
But if you receive a report that a child has been abused within a family, for example, in your community, you don't report it to the police. Now, can you explain the distinction? Why would that be?
Yeah, I would say again, as I read from the New South Wales booklet, as I strongly believe myself, as the scriptural principles highlight, we respect the rights of the individuals, the family, the survivor in the case of an adult, as in the two cases that have been considered, to make that determination. We've not said that we've had a procedure or process of automatically reporting it to the authorities. The Commission has brought to our attention that there, in addition to mandatory reporting, there are other legal implications to having that information. But I understand your point. Our process has been to respect the rights of the individual or the family. And I think, as has been previously quoted from 2 Corinthians 1:24, it says, "We're not the masters over your faith, we're fellow workers for your joy." And Galatians 6:5 says, "Each of us shall carry our own load of responsibility." So it's been mentioned that we control every aspect of family life. That's not the case. We respect the rights of families to make some of those decisions, but I do understand your point.
Well, is it not the case, Mr. Spinks, that it's because child sexual abuse is regarded as a sin within the Jehovah's Witness faith? It's a very serious sin, I'll grant you that, but it's regarded as a sin, but hasn't been recognised to be a crime.
Well, that's totally wrong. Not only is that printed, that we view child abuse as a sin and a crime. There is no worse sin and crime than child abuse. So I understand the basis for you expressing that, but that is totally the opposite to the truth with Jehovah's Witnesses.
No further questions.
Can you, Mr. Spinks, just help me to understand the role of women in the Jehovah's Witness Church? There are some fairly strict biblical New Testament injunctions about the role of women. Are they adhered to by your church?
I promise to give a short answer, Your Honour. We have such respect for our wives and women. We see scripturally that the role of teaching in the congregation is for the elders, for the men. Who does the bulk of the preaching work and adds the momentum? My wife, the other wives. We have a reputation for showing great respect for our wives. I understand what you're saying in 21st century Australia for a religious or faith-based organisation to say that the men are going to be elders. I understand the challenge, but that's our scriptural stand.
But are you saying to me women can't be teachers in the church?
I think when that was discussed previously, if we're saying, as in a church situation, the priest at the pulpit or whatever, we understand scripturally that's the role of the elders. Are the women involved in teaching, in the public preaching work, in the bulk of the ministry? Yes, they are. They do the bulk of that work, but I'm not trying to...
Are they allowed to speak in the church?
I think anyone who's been to one of our congregation meetings would say a resounding yes to that.
Corinthians says they can't.
The context there is the elder, minister, priest standing up and giving a Bible lecture to the congregation. That's the role of the elders. The women, as with all others, non-elders, amongst the men, our children, they all participate, question and answer, commenting freely, and presentations off the platform.
We'll just look at 1 Corinthians 14, 34 and 35 for me. Have you departed from the scripture in your current practice?
Not at all, Your Honour. I think...
would you read them out so everyone knows what we're talking about?
34 and 35?
Yeah.
Very good.
Well, you better start at 33, I suppose.
Okay. It says, for God is a God not of disorder but of peace, as in all the congregations of the holy ones. Let the women keep silent in the congregation, for it is not permitted for them to speak. Rather, let them be in subjection, as the law also says. If they want to learn something, let them ask their husbands at home, for it is disgraceful for a woman to speak in the congregation.
Well, do you follow that injunction or not?
If we read the whole chapter, I'm not suggesting that we do, but if we read the whole chapter, we'll see that the reason it starts with a God of disorder, not of disorder but of peace, is that there was disruption in the congregation, and the Apostle Paul, who I might mention was a single lawyer, spoke in a language that we would certainly phrase a little differently today. His point was it was the role of the men to stand up and teach God's word from the pulpit to platform. And so do we try and over-literally interpret that? The Gospels are full of the women doing the preaching and sharing in the work in the congregation. That's just a really strong statement addressing a particular situation.
So you don't follow that one?
We do not have sisters who are elders teaching from the pulpit, but they are actively involved in speaking and discussions and question and answer.
That's the question. So the answer to my question is you don't follow that injunction?
Well, it's out of context, I'm sorry, Your Honour, because the context is the priest preaching from the pulpit.
All right.
Just on that, I think the transcript may have picked up the wrong reference. Is it 1 Corinthians 14?
No, I've lost it now.
I think the verses were wrong, 34 and 35.
33, 34 and 35.
Chapter 14.
14, yeah.
Thank you.
33, 34 and 35. I mean, there are other references in a similar vein, and you've probably travelled this territory many times, haven't you? Because, as you know, many churches don't interpret and apply those injunctions in the literal way that your church does.
That's correct.
You know that?
I do.
Does anyone else have any questions?
I do, Your Honour, if I may.
Well, who goes first?
All right, I do, I think.
All right. Okay, Ms McGlinchey.
Mr Spinks, my name is Miss McGlinchey and I represent Monty Baker in these proceedings. Mr. Spinks, can I just ask, does the Jehovah's Witness Church conduct children's activities such as Sunday school or Bible classes for children?
No.
They don't?
No.
They don't have any child activities?
No.
Even creches?
No.
Childcare centres, anything like that?
No.
All right. So there's no activity where children are supervised alone with a Jehovah's Witness volunteer?
That's correct.
Thank you. Mr. Spinks, could you look at your first statement, paragraph 66? Just want to ask you some questions about the role of the regular pioneers. Now, as I understand it from the viewpoint of a lay person, a regular pioneer preaches in the community, in public. Is that correct?
Yeah, all of Jehovah's Witnesses preach publicly in the community. A regular pioneer is someone that says, I want to expand my ministry, but what you say is correct, yeah.
So they, the regular pioneers, may preach in a public place, such as a shopping centre or something like that?
Yes.
All right. That they also go door to door and knocking
Yes.
on people's doors and
Yes.
attempting to engage people in conversation and to communicate to them your understanding of the world. Is that correct?
That's correct.
Or Jehovah's understanding of the world?
Yes.
Right. And that may also involve going back on a number of occasions and taking part in family discussions and returning to the home and being invited into the home. Is that correct?
Yes, Jehovah's Witnesses conduct Bible studies with people, yes.
All right. I'm talking now in particular about the role of the regular pioneer, not generally. Do you understand that?
Sure.
Okay. Now, there is, and as I understand it, the regular pioneer strategy, for want of a better word, has been quite successful in growing the flock around the world.
I don't know how to quantify that. I guess I have no reason to question it. I guess a missionary, a special pioneer, regular pioneer is by nature going to spend more time in the preaching work.
All right. Now, there is an application to become a regular pioneer. You can't just decide yourself that you're a regular pioneer. You need to go through a process. Is that correct?
Yeah, I mean, anyone can expand their ministry, but as a regular pioneer, that's right, there's an application.
And that application form is attached to your first statement.
That's
correct. Could we look at that, please? Do you have that in front of you?
I do.
All right. Now, there are a number of questions that the applicant is asked about that would be considered in whether they're an appropriate person or not. In the question 6, number C, you ask, have you ever engaged in child sexual molestation?
Yes.
All right, okay. Now, the next one, D, if yes, when? Correct?
Correct.
All right. So you would be expecting a person to disclose that to you and you would ask further questions, such as when?
That's correct.
All right. And the next question is, are you now of good moral standing and habits? Is that correct?
That's correct.
All right. Now, would I be right in assuming that a person who does declare that they have engaged in child sexual molestation, if they are now a person of good moral standing and habits, would not be necessarily prohibited from taking on the role of regular pioneer? Is that correct?
Just trying to unravel the question there, but
All right.
I think if in question 6 there are a whole list of things, and
Yes.
the following question in 7, are you now of good moral standing and habits? If your question is if somebody says, yes, I engaged in child sexual molestation, that consideration would then be given as to whether they would be allowed to regular pioneer.
All right.
That's if they honestly answered the question, of course.
Of course, but we're only dealing with if they say yes. So, answering yes to that question would not prohibit you from taking part in being a regular pioneer.
The short answer is yes, it would. The longer answer is depending on the circumstances, as we've openly provided information. So perhaps if it was decades ago, I don't want to say anything to minimise or compare the nature of offences, but we deal with situations where perhaps a very immature 22-year-old is involved with a mature 16-year-old. They might even end up marrying or whatever, but there are situations where by definition it's child sexual molestation. We don't want to condone a child abuser by allowing them to, as the Organised to Accomplish God's Will book says, they should be exemplary and known to be exemplary.
All right. So what if a person says yes, but they also say they are now of good moral standing and habits? What further inquiries do you make?
The elders are instructed. There is a letter, by the way, it's in the submission or in the tender documents. I believe it's July 2014, thereabouts, that actually sets out the process. So the elders would then get all the details of that and write to the branch office. So it would be held up at that point. As soon as the, remembering that this is the document that's given to the applicant,
Yes.
as soon as that person puts yes to question C, yes, the application is held up, and then we'd start that process of discussing with the branch office what details are known about that.
All right. And are there a set of guidelines that you would use that in assessing that, or would it just be the judgment of the elders?
No, they contact the branch office. So the full details are provided to the branch office. The principles of the S66 guidelines that have been looked at before, and the Bible principles, the same is applied in this situation.
All right. Is there any external checks that you would undertake? And by external, I mean, for example, a police records check. Would you seek one of those?
I think as we've in our documents show that where working with children check is required for ministers, I think there's about 7,000 now, but for a regular pioneer, we have no requirement at this stage that's the case.
Can I just get you to address your mind to a situation which I'm suggesting of a person has said yes, but they've also, to that question, that they have engaged in child sexual molestation. They're also saying that they're now of moral standing, good moral standing and habits. And I understand that there's a process with head office, but would you, in that circumstance, seek any external tests for that, such as a criminal records history?
I think we've...
Is that the answer no?
The answer is no.
All right. Would, in that circumstance, you require a person to provide a working with children check?
That's not been the case.
So the answer is no.
Correct.
All right. Are there any criminal matters which, simply by having a record of that criminal matter, such as rape, that would in every case exclude you from being accredited as a regular pioneer?
Could you repeat that again, please?
Sure. All right. Are there any offences, such as rape, that would in every case exclude you from taking up a position as a regular pioneer?
I think for me to give you've asked an absolute question there.
I have.
So my answer is for the reasons I explained earlier. I don't think I could say absolutely that 20, 30, 40 years down the track on some specific situations. The question is too absolute and hypothetical, so I can't answer in the positive.
All right. Okay, so the answer is either no or you don't know.
I think the answer is, I'm not suggesting, you asked a question and I've not answered in the affirmative. I think if we had the specific circumstances, the short answer is no, there is no absolute, if that's the answer you're looking for.
All right. Does the church undergo any kind of risk assessment process where you look at the activities you're involved in and apply a process by which you assess both the risk to your own people and the risk to the community that your own people may present to them, such as being present in their homes?
If you're asking about have we engaged or done an external risk assessment. I don't know.
Do you recognise that it may, in some circumstances, be a risk to the public sending out people into people's homes who may have previous criminal histories for violent offences, say?
I think that's a valid question that applies across the community in every walk of life.
Mr Spinks, I'm not asking you about across the community. I'm asking you about Jehovah's Witness practices.
Again, your question is fairly sweeping, and I think it does apply to the broad community. Are you saying, is there a risk in any case of somebody who has committed a sin or a crime in their past being some risk to the public? I'd have to say absolutely yes, with Jehovah's Witnesses or any other organisation or individual.
All right. Could I ask you to look at paragraph 73 of your first statement about elders? Mr Spinks, you set out in that statement, if that could be brought up. All right, I think I've got it anyway. There are a number of considerations and characteristics of a person, of a man, before they can become an elder. And I think the number 6 is presiding over his own household in a fine manner. Now, that comes from Timothy 3:2, but it's not a complete stating of what Timothy says on that point, is it?
Can I read it in context?
Yes, of course.
So it's an open expression in the middle of a series of verses. What was your question?
All right. Timothy 2 says, in describing the characteristics of an overseer or an elder, a man presiding over his own household in a fine manner, as you've stated, and then there is a comma and it says, having his children in subjection with all seriousness. What does that mean to you?
What does having your children in subjection
mean?
I would suggest exactly as it says, that I don't think any caring parent would see it otherwise, that children are subject to the care and authority of their parents. I wouldn't imagine that any of us as kind, loving parents would see it any other way.
Well, it doesn't say kind, loving parents. It says having children under the subjection of the father.
I think
it's a very strong word.
Well, I think it's out of context, because if you read on to verse 5, makes the application of it where it says, and don't miss the word in the middle of it, for if any man does not know how to preside over his own household, how will he care for the congregation of God? The point is, if a man has unruly children who don't obey the parents' instructions, don't cross the road, don't take drugs, then if a man does not have the capacity to have his own family in a loving setting, then how can he do that for the congregation? So I personally would just be a little cautious about reading into that a manner or that's just totally not in harmony with the scripture. For myself, I would say that.
All right. To me, and correct me if I'm wrong, but the word subjection implies power and control, perhaps excessive power and control.
Well, I don't know what sort of family I think you're referring to there, but certainly not the case in my family. I like to think that my son, who's turned out to be a beautiful adult, was subject to me when I told him don't take drugs and don't get mixed up in the wrong crowd. And if that's subjection, I'll accept it and be happy to continue.
Well, BCG has given evidence about being under the excessive control and power of her father, who was an elder.
Again, just you probably need to be cautious to make sure that we stick with the facts. He wasn't an elder, so just if you could be cautious with that.
I'm sorry, if that's correct.
Apology accepted. In addition...
He was a ministerial...
Thank you. In addition, if if anybody in this commission or anybody of the thousands in Australia that are listening in and think that BCG's father was anything but a tyrant, some horrific recollections that she makes has nothing to do with all the kindly families in the broader community. He treated her in a diabolical manner, and I've no excuse for what he did. I'm just grateful that he's ultimately felt the consequences of that, and what BCG says she has every right to say, and we've no question over that.
Would you agree, or if this is within your knowledge, that the idea that children should be under the subjection of their fathers is, in the wider community, a very old-fashioned concept?
I'm shocked to hear you say it. It's all I can say, and I apologise. I'm shocked to hear you say it because I don't think there would be a parent, and I've got 2 beautiful grandchildren who I would take the same approach with, and I love them to pieces, would expect that you're going to let your child run on the street because you don't have that measure of authority until they become of an age where they can make good moral decisions. So if your suggestion is that parents should have no authority in relation to their children...
Well, I think, I'm not making that suggestion.
Well, I'm struggling with the word subjection being misapplied.
Right. Well, you are biblical literalists, and that's what's in the Bible. It doesn't say loving authority, it doesn't say care, it says subjection. The point that I'm trying to make, and I'll get to it a little bit quicker, is that do you think that by following biblical structures such as that perhaps children would not feel able to make complaints about their fathers if their father is the source of abuse, or to make complaints generally?
I think it's, with respect, please don't think I'm contending with you. You're expressing viewpoints and I'm expressing mine back.
No, I'm asking...
It's such a broad, sweeping, ill-informed comment that what you're doing is taking a tyrant of a man who's been to prison, that we won't let back into our congregation, who mistreated his daughter, and insinuating that loving...
I think the question's being put to you generally, not specifically. We had this difficulty before. Can you answer it in the general, which is what's being put to you, rightly or wrongly, is that by using the word subjection and creating a relationship of subjection, there's a real risk that a child will feel unable to complain about the actions of their father. Now, I have to tell you that I can understand the proposition. Is there an answer to it?
Again, Your Honour, I just invite anyone to visit our families. I can say no more than that. Just meet the families, see Jehovah's Witnesses. That's not the way. Was BCG's father, are some fathers like that way in the community generally? Absolutely, and I loathe it. But Jehovah's Witnesses love their children, support them, care for them. I understand the point, and if parents are authoritarian with their children or subject their children to unloving conduct, then I reject that and I loathe it.
Thank you. Nothing further.
Anyone else? Sorry?
Oh, you can...
I heard a voice.
I have a few questions.
Yes, very well.
Mr. Spinks, my name is Gallagher and I represent BCB. Are you aware of BCB's experience with Jehovah's Witnesses?
Yes, I heard her testimony.
And you would know, wouldn't you, that she was involved in a situation where the abuser was brought to her home with 2 elders. Of course, that is something that are you saying now would probably not occur?
I'm certain it wouldn't. The fact that she was 22 years of age is irrelevant. I think it was an inappropriate setting, yes.
Ms Gallagher, can you just bring that microphone
Oh, certainly.
so that everyone at home can hear you?
A moment.
It'll move.
Now it's moved. Sorry, I beg your pardon. And so you're aware, aren't you? Did you watch her evidence or listen to her evidence?
Yes, I listened to it, yes.
Right. So you're aware that she and her husband, who was fairly young at the time, both handed themselves over to the elders in the sense of trusting them with the process.
Yes, I understand that.
And the process, and this is unsatisfactory, I think you'd agree, was not explained to her or her husband.
I understand that. I have no reason to question what she said. I accept what she said.
And of course that's an unsatisfactory turn of events for them in the sense that the process of the inquiry, the investigation wasn't explained.
Certainly that's her recollection. I have no reason to question it, and it wasn't a good setting.
No. So you agree it's unsatisfactory?
That was at that time, absolutely.
Yes. As it stands now, just as to practicalities, if a young child comes forward or there's complaint from a young child, of course they would not face their abuser. Is that so?
That's correct.
All right. So there's a statement or the allegation will be put in writing in some way. Is that right?
That can be the case, yes.
Would that allegation be taken by an elder?
It can be the parents. I think there's several examples of that in the case files that you may have read.
No, I haven't.
It's in the case files. Yeah.
Right. So what if a parent were an alleged abuser? What would be the situation?
Then it would need to be the guardian parent or whoever the child had come to seek support.
Right. So not an elder.
I think we've made it clear that the statement can be taken by two witnesses. The elders are involved in the process. We've made that clear. Who actually is the best person? And again, I think you'll find in the case files there's some examples where parents have provided that.
I'm just envisaging a situation where a child may still be embarrassed in relaying detail about sexual assaults to them and may minimise the abuse because of that embarrassment. That's a possibility, isn't it?
Yes, it is.
And it's the case, isn't it, that as Mr. Stewart was asking, that if one repents one's conduct, if one is an abuser, then the punishment is reproof. Is that correct?
Well, that's extremely simplified, but if the individual was genuinely repentant, and my experience has been that would generally relate to historical cases. It'd be very difficult for anybody to conclude that somebody who had recently abused a child, it would take an enormous convincing that that their repentance could be commensurate with the degree of deviation.
Yes, but certainly if there was a situation, the current process lends itself, doesn't it, to the possibility of the abuse being minimised by the person who's alleging because of the way the statement is taken. That's a possibility, isn't it?
Certainly, that's a possibility.
And that because of the lesser punishment handed out for somebody who repents, then they may indeed confess to harm that they know to be inaccurately conveyed.
I think I've followed you through there, but look, everything you're saying is just plain common sense. I agree with it.
Certainly there's an inducement to confess to wrongdoing, isn't there, in the sense of the punishment is less, one isn't disfellowed.
Disfellowshipped, right.
Disfellowshipped.
Well, again, each situation would be different, but can I suggest that we've seen situations where people don't tell the truth. It happens in all walks of life, and there's no question that that's happened amongst Jehovah's Witnesses. So if somebody doesn't tell the truth, if somebody deceives and covers up what they are, what you say is that that can impact on the outcome with Jehovah's Witnesses as it can with any judiciary.
If you might address yourself to my question, that the prospect of lesser punishment, if you like, acts as an inducement to confess to wrongdoing. Do you agree that that's a possibility?
So you're suggesting that somebody could pretend to be confessing and repentant to try and not be disfellowshipped. Is that a possibility? You'd have to say yes.
Just as to another practicality, if an allegation of wrongdoing were sexual misconduct in relation to a child were to come to your knowledge and the investigative procedure within the church wasn't embarked upon, but the police were called straight away.
Yes.
The investigative procedure within the church would halt at that time, is that
Yes,
so?
and the documents would show that, yes, that is the case.
And the elder, if it is an elder, would be stood down waiting for the outcome of the police inquiry, is that right?
He's deleted as an elder.
Pending the outcome?
No, he's deleted as an elder. So what you're saying there is if we have an investigation that where there's evidence or confession or whatever, we hold up any further involvement with the individual at the request of the police. We've had experience with that. We respect their role and we step back, but he would be automatically deleted and announced initially.
So but that's not a permanent deletion, is that so?
No, that's a permanent deletion.
Right. Is that the same as disfellowshipped?
No. So I think we're again with total respect for everything that's happened. I think we call it deletion. The church may call it, if it happens, defrocking or laicizing or whatever. But where an elder or ministerial servant is involved in child abuse offences, they are immediately defrocked, deleted. But the judicial process of disfellowshipping the person, expelling them, would hold up. We don't want to interfere with the police investigation.
Mr. Speaker, I'm talking about before the church has conducted any investigation. If the church did not conduct an investigation itself and just immediately called the police, would that person still be deleted?
I think we'd need to, and as you would appreciate, we'd need to verify that there actually is an allegation, but I think would be such a rare situation where the police are dealing with a child abuse allegation and we don't immediately delete the person. And for the reasons of this, remember, we're not talking about paid clergy and pensions and all those sorts of things. We're talking about a volunteer local minister who should not be an elder until the whole matter is resolved and he can be irreprehensible again if it's proved to be a false allegation, which would be rarely the case.
So do you agree that it'd be best practice to, where an allegation is made of child sexual abuse, for the phone to be picked up and the police called and the person deleted until the process has taken its course outside the church?
I think even the police or the authorities would have a little issue with what you're suggesting there, that before an allegation is even established, that an announcement or a deletion is going to take place. But certainly, I think we're probably actually covering the same point from a different perspective. We're not going to leave an elder as an elder where there's a matter involving child abuse.
Where you say the police would have difficulties in proceeding where an allegation hasn't been established, I'm talking about the police establishing whether an allegation... Well, I withdraw that. Ultimately, of course, it might become a matter for a jury to determine whether a matter has been established. Do you understand that proposition?
The person would be immediately deleted. When the police have evidence, whether it fits in with our rules of evidence or otherwise, if an individual is dealt with by the police, he would be immediately deleted as an elder. If I may have misunderstood where you're heading with that.
So it would take perhaps the person being charged for the deletion to occur?
Well, again, I need to know the specifics. I don't know of a situation where the police have dealt with somebody for child abuse and we haven't deleted them as an elder.
Just in relation to prevention within the church, I take it that every Jehovah's Witness would be aware and live by the two witness, will certainly be aware of the two witness rule. Is that a fair assumption?
Well, I think anybody that reads the Bible or reads our publications, associates with Jehovah's Witnesses, would be aware of the Jehovah's Witnesses know their Bibles pretty well, but whether every person that comes to a Kingdom Hall, I can't comment on that.
All right. So that if, and of course you'd agree that that sexual assaults, given the nature of the offending, would occur just with two people present generally. Do you agree with that proposition?
I think we've been there, absolutely.
All right. So that creates the perfect protection for an offender. Do you agree with that proposition?
It's a broad sweeping statement, but I think I covered that in saying that we don't have an expectation. It would be naive. We don't have an expectation that there are going to be two witnesses to a child abuse or sexual assault. And I think as I've stepped out, we understand that the two witness Bible requirement relates to just one specific step. I don't want to digress. The October 2012 letter sets it out in detail in paragraph 11 of the process, where even where the allegation is only one witness, the elders take precautions and there are warnings given. So
yes. I think it's noted there, however, even though the elders are not authorised to take congregation action where there is only one witness, the elders should remain vigilant with regard to the conduct and activity of the accused. Certainly, but I'm talking about prevention. I'm talking about moving forward in the sense that the two-witness rule would effectively create a shield for an offender who is part of the church who knows, well, I can do what I want. It's not going to be proved without two witnesses. Do you agree that that's something that might go on in the mind of an offender?
I can't speak for what goes on in the mind of an offender, but
if you could take yourself there,
well, I'd rather not. But you're hypothesising, and I agree with the hypothesis.
Mm-hmm. You indicate, I think there's a page 15708. You, in answer to a question posed by counsel assisting at about line 16, and this is just in regards to telling parents that they have an absolute right to go to the authorities if they want to. You understand, don't you, in BCV's case, that she wasn't told by the elders that she could go to the police. Are you aware of that?
Well, I
Can I make you aware of that? Do you accept that that was her situation?
23 years ago or whatever, I think that's been established that was her testimony. I don't question that.
Yes. The situation now, is it that, if you could clarify, are victims told that they have an absolute right, or do you just leave that to them to work out in accordance with Galatians, forgive me if I'm pronouncing incorrectly?
I'm just not sure that, again, I'm happy to answer the question again, but
I'll withdraw it, I'm sorry. Galatians says, doesn't it, that basically one must bear one's own load. Is that correct?
Well, and again, I explained that has nothing to do with not telling the individual that they have every right to go to the police. That has everything to do, as I've mentioned.
What is church policy, if I might inquire?
Would I be permitted just to finish that sentence? If not,
I don't want to waste your time, or indeed that of the Commission. If I might clarify my question, it could be that I'm just wanting to know what the church policy is now.
I'm happy to repeat it again.
Right.
In every allegation of child abuse, I'd open it and read it again, but I think the Commissioner might get frustrated with me, but in every allegation of child abuse, the elders are informed, reminded, as they've got written there, to make sure that the survivor victim's family are told that they have the absolute right to deal with it with the authorities, and that the elders will support them in that. So we have repeatedly said that.
And so certainly, and that's at a time when the elders may indeed have established to their own satisfaction that they believe the allegation.
Look, again, for the sake of the Commission, I'm sorry to repeat myself, but the Chapter 12 of the Elders' Handbook, if you recall, specifically says at the time they first hear of the allegation. So there may be no evidence, it may be hearsay. The first thing that they do is contact the branch office, and they are given that advice, and the elders relay that advice.
Well, and are you aware, and His Honour touched upon this, as to knowledge and belief, if some knowledge and or belief as to whether or not a crime has been committed. Are you aware of the gravity of the criminal sanction if one has a knowledge or a belief about a crime having been committed and one doesn't go to the authorities? And I'm talking about the elders.
I think the Commissioner, His Honour, did an outstanding job of making it very clear to me, and I've acknowledged the fact that while that's a relatively new understanding to me, I don't claim to understand the law. What I've recognised and humbly accepted is that every individual in New South Wales, and that's something that's going to face elders and our branch office more than every individual, that there is a law there that has a bearing, and I understand that.
Yes, right. Thank you, Your Honour.
Did you hear the evidence of Mr Davies? Queensland,
I did most of it, Your Honour, yes. So.
Did you hear his concerns about your processes and the risk to prosecution?
I did. I heard what he said, yes.
Yeah. If someone's accused of a crime, maybe sexual abuse or indeed any other crime, which comes before the elders, that accusation comes before the elders, is the person accused required to answer to the elders?
The elders would never, I may have dismissed the first part, but the elders would never, or the policy or procedure is that they would always follow up an allegation.
I understand that, but is the accused required to answer to the elders, answer their questions?
I would say in the congregation setting the answer is yes. Then if the individual failed to do that, it would be difficult for me to understand how we would continue in the congregation, or that the parents or victim wouldn't be encouraged to deal with the matter through another course.
So in order to, as it were, protect him or herself within the setting of the church, the person would be required to answer the questions of the elders, is that right?
I think the clear Proverbs 28 verse 13 says, confess your sins. Is there a scriptural obligation for them to confess their sins? Yes, there is. Could they refuse to do that? I guess the answer would be yes.
What about not confessing your sins but articulating your defence? Would you have to do that?
The accused?
Yeah.
Yes, if there was an allegation against an individual and he refused to answer that allegation, the individual would be disfellowshipped from the congregation ultimately, because again, as the charge of brazen loose conduct is an absolute disregard for the authority and standards, so he would be disfellowshipped if he refused.
Well, it's probably murky territory for you, but do you understand where we've stepped into now in terms of the conflict or potential conflict between your processes and the civil law?
Yeah, I do understand the reasoning and I'm appreciative of it. I acknowledge what you're saying.
What's the answer?
I think we're looking forward to the recommendations of the Commission. We're favourable to mandatory reporting and we're favourable to documenting and addressing our policies wherever we can. That's a pretty sweeping statement, but as I said, we are motivated to do what we can within the scriptures to make sure that we make whatever changes are needed, Your Honour.
Well, you gentlemen will be able to help us on that question too.
Yes, Your Honour.
Mr. Tockley.
Yes, Your Honour. Your Honour, I just have one topic I wish to have some re-examination upon. I'll only be a couple of minutes, I think. Mr. Spinks, my name is Mr. Tockley, as you know. I represent the Watchtower Bible and Tract Society of Australia, as well as 3 other persons, including yourself, before this commission. Mr. Spinks, you gave some evidence earlier today about persons who are members of the Jehovah's Witnesses faith, including psychiatrists, psychologists, therapists and welfare workers. Do you remember that answer?
Yes.
Are policemen and women also members of the Jehovah's Witnesses faith?
Yes, there are Jehovah's Witnesses in all various aspects of the police force, yes.
And do you in the service department deal with members of the police force as part of your work?
Yes, we have a good rapport with the police for matters in both directions. Without digressing, we've had extensive dealings with the police in regard to the murder of the High Court judges and the bombing of the Kingdom Hall. So up till 8 o'clock this morning, we have a good relationship with the police force. I had a meeting earlier this morning.
And I take it there is no policy or scriptural reference which requires that the service department or indeed any other Jehovah's Witness not cooperate with the police?
It's exactly the opposite. If I can just be permitted just for one moment to show, because I feel that it's not been clear. It's been referred to, but...
Does Your Honour have any objection to Mr. Spinks referring to the... I take it's the Bible you're referring to?
Yeah, just a verse from the Bible, if I please.
We're about to embark upon a complicated question, but go ahead.
I'll make it brief.
You'll run into the problem of if the law is a problem and the police are trying to enforce a law that's a problem for Jehovah's Witness. That's the problem you'll run into.
I think this says the opposite, Your Honour, if I could be permitted to read it. But
yes, but you said what I just said before lunch, but anyway.
Romans chapter 13, if I could just be indulged just to read the verses, because this is our absolute conviction. It says, "Let every person be in subjection to the superior authorities, for there is no authority except by God. The existing authorities stand placed in their relative positions by God. Therefore, whoever opposes the authority has taken a stand against the arrangement of God. Those who have taken a stand against it will bring judgment against themselves." Verse 4 says, "For it is God's minister to you for your good. But if you're doing what is bad, be in fear, for it's not without purpose that it bears the sword. It is God's minister, an avenger to express wrath against the one practising what is bad." So Jehovah's Witnesses have absolute regard for the law in these areas. We want to be law-abiding. If, as has been raised, if there are areas of our processes that are not in harmony with the law in this matter, we will change them. We will make the adjustment. We'll continue to cooperate with the police. We love the police. We want to cooperate with the police, and if there are laws that require us, we will change our arrangements to conform to support the police.
Mr. Spinks, it's a complicated question. Before lunch, you rightly pointed out that the Jehovah's Witnesses did not comply with the Nazi obligations, and that's occurred or occurring throughout the world. You can't literally apply that Bible passage to all circumstances, can you?
I read before Acts 5:29 that talks about God as ruler rather than men. If a government, as the Nazis did or as South Korea does, says that I have to go and kill people, then I'll default to God's law and I'll go to prison for the consequences. When the Australian law says you report every case of child abuse regardless of the wishes of the victim, Jehovah's Witnesses will fully comply with it. There is no question about us obeying the law.
I understand that, but you have to make a judgment is the point, don't you? You have to, as a Jehovah's Witness, you have to make a judgment.
Not with regard to the law in relation to things that don't conflict with Bible principles, because reporting child abuse at any level does not conflict with Bible principles, and we would happily comply.
I take it from what you've said in answer to His Honour's questions, that you draw the distinction between those legal requirements of a government which are regarded as being in conflict with the scriptures, which you will not observe, and that's why you gave the examples of Nazi Germany and Korea, correct?
Yes, that's correct.
And those legal requirements which are in harmony with the scriptures, which Jehovah's Witnesses will comply with.
Absolutely.
And that's the distinction that you seek to draw.
That's correct.
Thank you. Thank you, and I have no questions. No more questions.
Your Honour, I did have a question, but I note the time.
No, you ask your question.
Thank you, Your Honour. Well, I had three, but I'll try to limit it, given the time. For the record, my name is Ms David, and I represent BCG. It's on this point of cooperation. This is with the other counsellors, psychologists and persons who would assist victims. I just want to be clear that it is not just in circumstances when the victim or the parents of the victim raise that they want to go to the authorities that you will advise them that it's their right to do so. Is it the case that you positively tell them that there are a variety of options and authorities that they may wish to speak to? Do you positively counsel them in that regard?
Well, again, I can't speak in the absolute, but my understanding would be that in every case we positively go to the parents and say, if you choose to, you'll have our full support. Do we go and say you must go to the police? We don't do that.
Well, I'm really asking you for somewhere in between there. It just concerns me with respect some of the language you've used, that you would cooperate, you will, you respect their right if that's what they want to do. Do you tell them that that is an option that is available to them?
In every situation, to my knowledge, we do.
Right. And that is what you counsel the elders?
That's correct.
Right. And that is a new practice?
Why do you say that?
Well, I represent BCG.
Oh, so did the
Yes.
elders do that 24 years?
No, in fact, she has made a statement that she was instructed to the contrary when she raised it some years later with the elders, that she was in fact advised that she would be defellowshipped if she did, and other matters. But I guess what I'm concerned is that victims and their parents or guardians are aware not only that they have that right, but of persons who they might go to.
I think I've answered that question. Did that happen 24 years ago? I have no intention of disrespecting BCG's recollection.
Yeah. And just if I could seek the Commissioner's indulgence for a minute, just in relation to the issue of support, because what concerns me that in your statement, I'm not going to go to each paragraph, but on a number of occasions you have said that you take steps, you advise the elders to protect and support the victim. Again, I come back to BCG, but it is plainly clear from her statement that she did not feel supported and she did not feel protected through that process. Do you agree with that from having heard her evidence?
Do I agree that was what her evidence was? Absolutely,
Yes.
I heard it, yes.
And you heard from the elders that they believed that they gave her support.
I heard that too.
Well, there's a clear disconnect there, isn't there?
There's two different recollections.
Well, no. What I want to suggest to you, it's not a different in recollection. There is a clear disconnect because while a well-meaning elder might believe that he has provided support, what it really highlights is that they are completely inexperienced and unable to provide the sort of support that a victim of child abuse needs. Isn't that what that indicates?
I think that's the longest question I've heard all day, but I think what I think what you're saying is if I had the power to be able to go back 25 years, I think...
No, Mr. Spinks. No. What's being put to you is that this is not a question of recollection.
Mm-hmm.
It's the fact that the report from the survivor as to the way she felt which is her own
Yes.
truthful account, is something which the elders obviously did not understand or appreciate. And that may be because of the limitations that old men, like me,
And me.
might have in dealing with intimate allegations from a young woman about what has happened to them.
Yeah.
Do you understand the point?
I do, and I accept that.
Well, accepting it's one thing, but then what's built into your process, if you accept it, is the risk in every case, when we're talking about abuse of this nature, that the survivor will feel unsupported and indeed may well be traumatised by the process. You understand?
I do.
And that's a very serious position for the Jehovah's Witness to be in, and a matter of concern to the Commission. Do you understand?
I do understand.
And that the case of BCG highlights that there are gross inadequacies in the way that the Jehovah's Witness congregation deal with these matters, notwithstanding their good intentions. I'm not suggesting that. I'm just saying that they are clearly, from BCG's point of view, as an example, I'm sure representing many other victims, that change needs to occur to ensure that there is a comprehensive regime in place to look out for her, not that the elders don't have that capacity. Do you agree with that?
Again, it was such a long question, but if I understand the criticism, and I think again I would say I do understand what you're saying.
And that there needs to be that is an area that you need to look at seriously within your processes, and to ensure that you can properly support and protect a victim such as BCG.
And continually do so, continually reevaluate and accept those observations.
And to accept those observations, precisely.
Yep.
Yes.
I agree.
Thank you.
Your Honour, there is one matter I should put to Mr. Spinks briefly. Mr. Spinks, it's just in relation to your evidence in the last short while where you said that elders are informed to make sure that the survivor or victim's family are told that they have the absolute right to deal with it with the authorities. And if I can take you to your Shepherd the Flock handbook, that's tab 120 at page 131. And you explained earlier that this is looking at paragraphs 18 and 19. From here is what you explain, the generic advice you give, and it's based on what's written here. And you'll see in paragraph 19, just below the bold, it says, if you are asked, make it clear whether to report the matter to the authorities or not as a personal decision. And I suggest to you that that's where the truth lies. The truth, in fact, is that you tell your elders, if you are asked, make it clear that whether to report the matter to the authorities or not is a personal decision, and that it's not something that you tell them in every case, not something that the elders are instructed to tell the families in every case, that it's their absolute right to deal with the authorities. Do you accept that?
No.
Is that another document that needs to change then?
Yes, I think earlier, if I can, I recounted under oath what we do and what we say, and have acknowledged that we certainly need to put these references together and document what is actually done, and I apologise that that's not the case.
Very well, thank you for your evidence. You're excused. And we'll adjourn until 10 in the morning.